We have a set of rules that specifically cover the conduct of lawyers in litigation. These are the rules that start with 3, that is 3.1 to 3.9. 3.5 is about impartiality. In other words, we want to avoid rigged trials. So some of this rule will cover jury tampering or bribing judges, but also decorum, which means avoiding behavior designed to disrupt or interrupt the proceedings, like doing a stunt in hopes of getting a mistrial so that you can have a do-over. Rule 3.5a starts with issues of illegal influence. It says, a lawyer shall not seek to influence a judge, a juror, a prospective juror, or other official by means prohibited by law. And so we're talking about bribes or threats of judges and jurors. Rule 3.5 continues with section B, ex parte communications. Some of my students have probably heard about this with relation to judges. A lawyer shall not communicate ex parte with such a person during a proceeding unless authorized to do so by law or court order. And again, we're talking about a judge or a juror. So let's unpack this a little bit, especially Rule 3.5b. Private meetings with a judge in chambers or meeting privately with a juror must include lawyers from both parties in the matter. So there's no side conversations allowed, whether in person or by phone or emails directly with the judge or any juror about the case while it's pending. We're very strict about this rule. Now, judges themselves also have a rule in the Code of Judicial Conduct against ex parte communication. So most judges will not give you the opportunity to do this. Also keep in mind that we have an exception for minor scheduling communications and so forth. A judge or a judge's assistant or clerk might call the lawyers one at a time, for example, in order to reschedule a hearing or a filing deadline on motions or something like that. But they won't discuss the merits of the case if only one lawyer is in the conversation with the judge at a time. Now, it's more serious, though, with jurors because we don't have a code of juror conduct. The juror may not even know what the rule is or that the lawyer is doing something inappropriate. So say, for example, that you have a trial and you're in the elevator at the courthouse on the second day of trial. And juror number 4 gets in the elevator with you and greets you and starts talking about the case, or they compliment you on your opening argument the day before. Well, you have to stop them right there and say, I'm sorry, I'm not allowed to talk with you as a juror. And they might feel a little snubbed when you do that. And if you do say that, I'm not allowed to talk to you, or if you continue the conversation, you should assume that the elevator doors will open and opposing counsel will be standing right there and will catch you, or that someone you don't recognize in the elevator with you is actually the opposing counsel's law student intern. And they're going to report this to the judge. It's a very serious matter. What if the juror comments on something unrelated to the trial, like the playoff games that are happening right then, or the weather? The answer is no. We do not want you to take a chance to charm the juror privately and make some kind of personal connection like that. When you refuse to talk to a juror who was just making friendly conversation or chit-chat, they're likely to feel a little snubbed or offended, but you can't have a conversation with them even if it's not really about the trial. So to be honest, most experienced lawyers, if a juror steps into the elevator with them, will just step off the elevator and take another one to avoid this awkward situation. Or you might start taking the stairs at the courthouse. The same thing could happen if you go to the diner across the street from the courthouse for lunch. When they take a recess or a lunch break, you may run into jurors there. They could be with you waiting in line to order sandwiches, and you start chatting with them. Well, you should probably bring your lunch from home and eat in the hallway in the courthouse, or get in your car and drive across town to a nice restaurant for lunch so you won't run into jurors, because the juror may be excited to see you and want to start talking to you. 3.5c is about former jurors. It says that a lawyer shall not communicate with a juror or prospective juror after discharge if one of the following conditions have been met. 1, the communication is prohibited by law or court order. 2, the juror has made known to the lawyer a desire not to communicate. Or 3, the communication involves misrepresentation, coercion, duress, or harassment of the juror, the former juror, by the lawyer. Now, it's fairly common for lawyers to get a chance to interview jurors after a trial. This could be at the courthouse before they leave, or sometimes with a personal follow-up phone call or email a few days later. Sometimes the losing side lawyers are fishing for evidence of juror misconduct in hopes of having a basis to ask for a mistrial. But more often, it's that lawyers want to get helpful feedback about which witnesses, let's say, that the jurors found credible, or what, if anything, changed their minds as the trial progressed, and so forth. And to be honest, this can be a useful way for litigators to learn more about how jurors think. It could improve your lawyering skills. You should be aware, however, in practice, that some jurors are mean or are bigots or will say things that hurt your feelings. They'll criticize your hairstyle or your outfit or your ethnicity or your age and so forth. And so you have opened the door for them saying, I just don't like people that look like you, or I don't like people that sound like you. Now, that said, if the trial is done and the jury is discharged, it's usually permissible, normally permissible, for lawyers to talk to jurors, unless one of the 3 scenarios in this rule apply. There's a court order. The judge has ordered the lawyers not to talk to the jurors. This is rare, but it happens sometimes. Or a juror has expressed that they don't want to talk to you, either expressly or by ignoring your first few messages, and you keep calling and at some point it's harassment. Or you are kind of trying to intimidate or pressure the juror into telling you something that you want to hear. And at some point you cross a line and you have violated the 3rd part of this rule. Let's move on to 3.5d, which is about intentional disruptions. A lawyer should not, it says, engage in conduct intended to disrupt a tribunal. This could refer to silly courtroom stunts like doing cartwheels or having a loud, angry outburst. But it could also include more mundane examples like repeatedly delaying responses for discovery requests or flooding the court with an avalanche of unnecessary and repetitive motions, or other conduct that's designed merely to derail the proceedings. All of those things could lead to the lawyer being subject to discipline. Moving on, the comment 5 to this rule says that the duty to refrain from disruptive conduct applies to any proceeding of a tribunal, including a deposition. So if you're doing a deposition, usually before trial, don't do things during the deposition that are designed to just merely to derail the deposition. An angry outburst or something that's supposed to throw the other lawyer off and kind of ruin the whole point or make it an exercise in futility. Okay, let's move on. Can lawyers review jurors' social media accounts? And the answer is yes. Either in anticipation of jury selection or could they monitor their accounts during trial? The American Bar Association addressed this question in detail in an ethics opinion in 2014. And they concluded that it is permissible in most cases for a lawyer to review a juror's internet presence or social media posts before and during trial. But the lawyer cannot communicate directly or indirectly with a juror or potential juror. And that means no friend requests or follow requests are allowed with the jurors, nor can you like their pictures or posts or reshare or repost things and so forth. You can look at what they're posting. So you may not, either personally or through an agent, send a friend or an access request to a juror on social media. So for example, some people have their account private and you're wishing you could look at it. You're just out of luck. But anything the juror has not made public would be a type of ex parte communication prohibited by Rule 3.5b. But if they have made information public, it's fair game for the lawyers to look at it and get a sense of what the juror is like and what they think and how they look at the world. Note that it does not matter, according to the ABA, if the juror can tell who has viewed their social media page. That's not the same as a request to connect or follow or become friends online. A few social media platforms like LinkedIn allow users to see who has looked at or visited their page. It's fine if jurors know that the lawyers are watching them. Just don't like any of their posts or reshare or repost them. Also keep in mind that lawyers must report juror misconduct if they discover any while they're reviewing their social media, even if it's favorable to your side. Sometimes lawyers or jury consultants monitor jurors to get hints about how the jury or the overall is reacting to the trial. Do they cryptically complain about the stories they heard that day? Do they talk about jury duty being frustrating or a waste of time? Do they rant about how much they hate big corporations or insurance companies or things like that? Any type of category that may describe or relate to one of the parties in the case. But sometimes the lawyers are just watching for juror misconduct. Publicly, they're watching to see if the jurors are publicly discussing details of the case and asking for advice from their friends, like evidence or testimony that was offered. Or maybe they're looking for evidence of jury tampering by the opposing party. And if they find it, the lawyer has to report it. Now, this concludes our overview of Model Rule 3.5. In the next video, we'll move on to Model Rule 3.6.